Hey, Judge, don't we take away phones for this?
This isn't something this is not something.
But it's DA Hilton. Who cares, right? You took Weinstein's phone away and another person's phone away. I can't remember who it was. But, Hilton had an embarrassing day today. I'm going to give y'all spoiler warning. Keith Adams with the regular A+ that he typically puts up. Man, it was embarrassing today. And I'm going to really break down why it's embarrassing. Some of y'all going to be like, nah, he made some valid points. It's not just the points that he made. It's the underlying stuff that's going on. Let's get to it.
It's not hearsay. It's not speculation.
Have you already asked Mr. Copeland already about guns and the purchase of guns on in your direct thus far?
I don't recall if I've asked. It's not hearsay. It's not speculation.
Have you already asked Mr. Copeland already about guns and the purchase of guns on in your direct thus far?
I don't recall if I've asked.
I'm only gonna let you go so far, okay? I mean, I think you've got to ask some questions in regard to that. I mean, if they haven't been asked, I'm not saying you can't ask, play it. If you haven't asked them already about this, there's some foundation that needs to be played.
But we can impeach in multiple different ways. The one way is impeachment by contradiction. Another way is impeachment by contradiction.
Okay, all right. I'm not inclined to let you impeach him by contradiction at this point because because he hasn't testified about anything about any guns or anything like that, and you haven't asked him anything about any guns, which you just said. So if you had asked him about guns and then he coupled with the potential not being truthful, you could probably at that point in time the foundation would probably be satisfied. I agree with you. You can impeach in many ways, but I think your foundation is lacking at this point. I'm just saying, if you're going to ask him that so you still got him on direct. You can ask him those questions, and then if he denies it or whatever else, then you may be able to get into some of this. So I'm going to exclude it at this point in time, Mr. Adams.
All right. And I'm sorry, let me just add that before Ms. Hylton responds. I did want to address this whole issue because we keep coming back to it. That Mr. Copeland, who is on direct currently, one of the things he said is something to the effect of, I made that up. I made this stuff up. Well, that's not really carte blanche to impeach him with everything that's in his statement. We've already objected on behalf of Mr. Williams, and I think everyone else has, to the recording being played at all. But I just want to point out that she doesn't, if they're attempting to impeach him, you got to kind of pick and choose what you're impeaching him for. And you don't just get carte blanche because at one point he either says, I made that up, because he also said, yeah, I probably said that. You don't get to say we're going to impeach him by just playing everything, and every single thing in his statement is relevant and comes in and is not subject to any other objection. So that's my position on that.
All right.
I do believe the court should hear the portions of this particular section, Your Honor, and it will begin on page 413 at 411-14.
411-14?
Yes, Your Honor.
Through
413-35.
Okay. What's the state's position? I'll decide whether I need to hear it or not. But
Your Honor, we believe that Mr. Copeland is talking to this from not rumors, but from his personal knowledge about the fact that Quindarius Zachary is purchasing guns on behalf of members of YSL. Quindarius Zachary is an unindicted co-conspirator. Part of the state's theory in a number of instances that Mr. Zachary was a straw purchaser for a number of guns that were recovered by YSL members. Specifically, the one gun that Mr. Copeland has in his possession, the reason for the arrest that brought him into this interview was a gun that Mr. Quindarius Zachary purchased on his behalf. This section talks about where Mr. Zachary purchased those weapons from, and we believe that is relevant before the jury again going to the overall gang conspiracy in this case. It's not hearsay, it's what Mr. Copeland knows.
And so if I can just respond,
yes, sir.
Briefly, and
But I would say, would like the work to be played prior to this, and we can hear the constitution. Because while there is a transcript, there are some things that are indiscernible that I think the court will need to listen to and hear, and not just solely rely on the transcript.
Hey, yo, you. Can you subscribe and turn on that bell too? Because when you do, you're helping unbiased independent news.
Leave my look.
With the gun you got caught with, you said it's my stuff guns. Why he wouldn't come claim it? Was that his big homie?
Saying I had no clue why he can't come clean. I thought it was in his name.
Who name?
I thought it was two guns.
That girl ain't nobody. It's in somebody's name, but it ain't his name.
Yeah, I just thought it was.
Right.
Yeah, you had it everywhere. So you had it everywhere.
He had a drum on it. He had a drum on it.
I went.
On that gun. I need to let y'all work or the DJ on the board.
He gave me.
What? When you put it on?
Cause they told you, yeah, no, these here, man, they gonna steal it, they gonna run out and all this.
So you give it the D. So why would D do
The
it?
D got another gun in the name, AK Dog gun.
Really?
Yep.
When did you buy that?
In January.
This past January?
Yeah.
Where you buy it from?
The same pawn shop.
No, sir.
Yes, he did. He got one pawn, he bought the AK first. To Draco.
You ain't buy it from there?
Yeah, he bought it.
Cool on that. Cool on that.
He bought a Draco.
It ain't from there. It ain't from Arrowhead.
Shit, I don't know where he bought it from. He bought it at pawn shop.
And he bought it from Doug.
No, he bought it himself, but sold it to Doug. Yeah, we were jugging. He was buying and selling to him for high price.
So what if y'all found a stolen gun? Y'all still sell it to him? You just sell it dirty or something?
Nah, he buying with him. He buying stolen gun, legit gun. If I call him right now, still I got something to get back. Man, buy everything.
Just because he got it.
We'll pause at 4:13:35. He wanted to say he's not making this information up, and so.
Well, why would you think that it could be played before you ask the witness the foundational questions? I mean,
Because that's the same reason. It's not private. Say again, Your Honor, the premise, the reason why this video can come in.
but I'm only going to let you go so far, okay? I mean, I think as you got to ask some questions in regard to that. I mean, if they haven't been asked, I'm not saying you can't play it. If you haven't asked them already about this, there's some foundation that needs to be played.
But we can impeach in multiple different ways. The one way is impeachment by contradiction. Another way is impeachment by contradiction.
Okay. All right. I'm not inclined to let you impeach him by contradiction at this point because he hasn't testified about anything about any guns or anything like that. And you haven't asked him anything about any guns, which you just said. So if you had asked him about guns and then, he coupled with the potential not being truthful, you could probably, at that point in time, the foundation would probably be satisfied. I agree with you. You can impeach in many ways, but I think your foundation is lacking at this point.
Suggesting that Mr. William and them is going to find out something about Copeland and, quote, knock your head off. He's talking to Copeland at that point. We've agreed, I've spoken to Ms. Hylton, we've agreed that that should be redacted.
Okay.
And I'll rely on Ms. Hylton to give us the time stamp on the video.
Let's see if we can get that. Ms. Hylton, madam?
4:16:11
Okay.
4:16:17.
4:16:11 to 4:16:17.
Yes, Your Honor.
Okay. All right. Continuing on.
I think for that reason. And I also think that what they're looking for is contained in other unobjectionable portions of the statement. And so I'd ask for it to be kept out.
What about, Mr. Adams, let me answer this for me, if you wouldn't mind.
Yes, sir.
What about the issue in the preamble of the indictment where it says, that members possess, let's just say it's just offered for that particular reason. What would your argument be at that point in time? Because it's up to the jury to determine whether or not it's relevant. But I'll make a threshold determination. But whether or not it goes to anything.
Right.
What would you say if I just said, well, it could be potentially admissible if just to show possession of illegal substances by YSL members, purported YSL members, because they have to first make that determination. But and then, of course, what it would be used for.
Sure. The preamble, to the indictment is really that's argument, right? What we get to, what they have to prove, and what we have to address is what's actually alleged in the indictment. What's alleged in the conspiracy, in the RICO count, and the specific acts. And we're put on notice by way of specific acts, and also by specific indictment numbers. Now, if they want to allege that Mr. Copeland and Mr. Williams smoking weed together at the studio is an act that is part of the overall conspiracy, then they allege it in there. But they haven't done that. Because by that logic, really, there's a lot of things that are said here by Mr. Copeland that aren't part and parcel of the indictment, but they can make the argument that, well, we said something about drugs in our preamble, and so all of that comes in. And I think that's essentially their argument, which I think does not control here. But my objection is just pretty straightforward, pretty simple. I think that is irrelevant. His character should be taken out. That's all.
Your Honor.
Yes, ma'am, you certainly may.
Your Honor, the YSL organization uses criminal activities to expand their criminal networks. So the fact that Woody started off as a drug dealer, this isn't about them smoking weed in the studio. What it was is that he was bringing him the drugs, that the fact that he started off as a drug dealer and then was able to get into the gang itself or the organization and become an associate is a parcel of the larger RICO conspiracy. He went from not just the person who supplied drugs, but he moved on to a more associate membership relationship, again, talking about all of the portions that Mr. Adams just cited. So we transitioned from you bring me my drugs to now I have embraced you into our organization. Now you are a member of our organization. Now you can take trips. Now I can give you money in the club. Now you are a part of our organization. And I think that development in and of itself is important and relevant for the jury.
Well, that's a really good argument, and that's something good for closing argument. But that's and it's fine for them to have a theory. All right. But just because they interpret it as such doesn't mean that there is evidence of that. You can't say that, well, him saying that we smoke weed together in the studio is evidence of him bringing him into a gang and them engaging in conspiratorial conduct. I mean, again, the state is fine to have whatever argument they want to have, but the court's determination is whether or not this particular piece of evidence is relevant and whether or not it impugns Mr. Williams' character by its admission. I think it does.
Or the content of her statement.
Okay, and stop right there, just if I can hijack you just a second. I don't have any issue with anything you said so far, and I think that you and Mr. Adams coexist in that space. However, the challenge you have is you've got to still ask the question about that area, and then I think it picks up from there. I'm not going to allow you to play it until you lay a little more foundations for that reason. I'm not saying you can't play it, but you still have to give that witness an opportunity to be heard on that particular thing, asking about the gun, asking about that. So I think that what Mr. Adams is telling you, and the court, the court kind of has some concern. That's why I asked you yesterday, was it discussed on direct? And you said, well, I'm going to check and see if it's discussed on direct. That's the predicate. So
if I could finish reading the next portion of Scanners, I think that addresses the court's issue. Scanners complains of the state's failure to confront Finch with the specific extrinsic evidence of her alleged prior inconsistent statement.
Okay, but you still have to ask him about the topic area.
So I want to get to the last portion. But
Okay.
As Bridgewater and Murdoch indicate, Finch's failure to recall making any statement at all about fighting, abuse, or anything like that, as well as her denial of the mall incident, and Scanners arguing with Lincoln relieved the prosecutor of the need to ask about specific statements.
Okay.
So that is where we're focused at. The fact that he says, I made it all up, relieves the state from having to go line by line and asking about specific statements.
I don't have any issue with that. I don't. But I still think you guys, it's not like you have to give the witness an opportunity to confirm or deny. I'm not saying that. But I think as a matter of, you've got to orient the witness and tell him and ask him questions about the gun. You can't impeach him on a gun when you haven't even asked him anything about that. Yeah, you haven't, just based on, well, I don't remember. He hasn't even said, I don't remember anything about it. So, I mean, I think you need to introduce the topic. And then if he says, I don't remember, I don't recall, then you can do that. That's why I'm saying there's foundation and predicate. I don't disagree with the case law that you cited in Sconyers but that's why I asked you has he testified as to that already? If he's testified about that and his memory's kind of, I don't know, I don't recall. Yeah, you can impeach him by prior contradiction or any other means that you think is appropriate under the circumstances. So I just want to make that clear. Okay.
Thank you, Ryan. So as it relates to this particular portion of the interview, Mr. Copeland, I believe in court, when asked how did he meet Mr. Williams, said, I met him at the studio. I was kind of like a fan. What this portion of what Mr. Copeland tells the detectives back in 2015 is that this relationship kind of grew. It grew from possibly him being the person who facilitated giving him drugs to a more developed relationship, which was not just a fan. We have pictures of Mr. Copeland and Mr. Williams at each other's homes, or it looks like at their homes or respective places where they live. We have Mr. Copeland and Mr. Williams on tour together. And this evidence about the development of their relationship is relevant as far as
So haven't you gotten testimony about that already from the witness?
No, because he made it seem as though it wasn't a very close relationship. What he said is, oh, I met Mr. Williams at the studio, and I was a fan of his.
Okay, well, how do you
development.
I'm sorry, hijack again. How do you justify then talking about him being purportedly Mr. Williams' go-between to acquire, illicit drugs?
So, Your Honor, again, we have charged in this indictment the fact that the members of YSL possess and sell and distribute narcotics. So this talks about that relationship. So this is relevant. This is already in the indictment. This is in the preamble of our indictment, Your Honor. Additionally, Your Honor, citing to two cases, Anderson v. State, 337 Georgia App 739, which is a 2016 case, as well as Moore v. State, which is 295 Georgia 709, which is a 2014 case, Your Honor.
Okay.
In both of those cases, it talks about relevant evidence as well as that evidence which incidentally places an individual's character into evidence. Your Honor, here in this case, there has already been testimony of Mr. Williams being stopped in a car with drugs. So this information with Percocet in 2017, I believe he was also stopped with marijuana inside that same vehicle. So this information about Copeland talking about Mr. Williams and how he met him is not anything that is more substantially outweighed by its prejudicial effect, because there's already evidence before this jury about Mr. Williams being stopped with drugs in his car, he's being stopped with guns inside the car. So the fact that Mr. Copeland is talking about this is how they met is not substantially prejudicial, and it is relevant to talk about the development of their relationship from being, whether it was his supplier of drugs, to a more developed friendship, which is more than what the witness indicated on the stand. And furthermore, Your Honor, I believe in opening statements, Mr. Steele, when talking about the relationship of Copeland and Mr. Williams, tried to distance Mr. Copeland from Mr. Williams. And I believe in opening statement, Mr. Steele tried to assert that Copeland was more friends with Demekion Garlington, in which they are friends, but really try to distance what Mr. Copeland's relationship was with Mr. Williams. So I believe that the jury understanding the development of their relationship is important to assess whether or not they find what Mr. Copeland is saying in his 2015 interview correct.
The court's had an opportunity to take a look at those cases, in particular Anderson, and the court is of the opinion that given what the state is proffering that they wish to admit it for, that I'm in concurrence with the defense that it is not relevant for that particular purpose. It shows more the individual drug use, or more so than it does indicate in the preamble to the indictment that for the possession, sale, or distribution of obtaining money, weapons, or other property through acts of racketeering, including robbery, theft, and unlawful sale and distribution of drugs. This is more for this in this particular section. The court is of the opinion that it more so talks about how Mr. Copeland and Mr. Williams started their relationship in terms of the sale, or not the sale, but the acquisition of one by Mr. Copeland to 403 balancing test. There is other information in this particular transcript or in this particular video, which does show the relationship between the two. And I believe that that is more relevant in the circumstances. It doesn't kind of put us in this character issue. Now, this is my ruling on this particular portion of the transcript. If other things come up, or if the door is opened up by any other witness or any counsel's inquiry about this, the court will go back and take a look at that, okay? But right now, I'm going to exclude it.
Thank you, Your Honor.
Okay.
The next one, may I move on?
Yes, yes, sir. Unless there's any other argument by anybody else. Okay, go ahead, sir.
436, line 23, page 437, line 50. Relatively short passage. That's a portion of the interview where Mr. Copeland is talking about statements made by Mr. Williams' father. He talks about what the father either told him or what the father says he knows, what the father thinks about him, Mr. Copeland, talking to the police. Obviously, Mr. Williams' father is not part of the indictment. I don't believe the state's going to allege that he is an unindicted co-conspirator. The relevant portion, if we start at line 23 of page 436, just to give the court a flavor of what we're talking about, where Mr. Copeland says, line 23, and this comes on the tail end of the detectives asking Mr. Copeland about whether anyone has an issue with him talking to the police, whether they've ever asked him when he's talking to law enforcement. So Mr. Copeland starts at line 23 saying, somehow Thug's daddy, he be with Kente and them a lot, and Thug's daddy told me out his own mouth, like, he connected. You know what I mean? I don't know who he connected with, but he get all this information. He get a lot of information. You know what I mean? He said it out of his own mouth, and he like, you know what I mean? He knows what's going on. That, I'm gonna say N-word, because I think we've been throwing around that word for 3 years. That N-word told me he could change my identity and everything. That's what he told me before beef. Like, and when he said all that, I thought he was just talking. And when I came to Metropolitan, what's the name? He was looking at me crazy. I mean, and then from that day on, and hearing the little story, like I've been talking to the police a lot. You feel me? When I was telling the police, I wasn't telling them about what I should have been told them. I was telling them about what people are doing to me. You feel what I'm saying? So that's where it ends. That whole portion is really what Mr. Copeland is relaying to detectives, either what he heard from, what he knows of, or things said by Mr. Williams' father. Totally irrelevant, and certainly hearsay. And so, for no other reason other than that it's hearsay, that's irrelevant. I'd ask it if he extracted or excluded.
All right, State.
I don't know what it goes to.
Okay. Madam?
You're right. I think you need to continue to read the rest of that page, because the portion that Mr. Adams just cited is not out of context with what happens on the rest of the page, Your Honor. So if you continue on, starting at line 16, he says, I didn't want to tell them about my so-called friends at the time. But in the way he was saying, like, I talked to the police a lot, you know what I mean? Like, he knew I wasn't going to tell, but he knew I was talking to him. So I don't know how he gets his information. But when he said that, I thought he was just talking at the moment, trying to scare me up or whatever. And so I think that is the most salient line, is that we're not offering it for the truth of the matter asserted, which is whether or not Mr. Williams' father has connections in the streets, whether or not Mr. Williams, that's how he gets his information. But the effect on Mr. Copeland's state of mind and the effect on him as the listener, hearing whatever it is that Mr. Williams was saying to him, that's how he interpreted whether or not people knew he was talking to the police and what he was disclosing to the police. And so I think that you have to read all page 436, beginning at line 18, in conjunction with going all the way from page 437 to line 24. So we're not offering it for the truth of the matter of whether or not Mr. Williams Sr. is connected with anyone, but the state of mind of Mr. Copeland as to why he did certain behaviors, why he was concerned about who knew if he was talking to police and what was being disclosed to the police. And again, this goes back to Mr. Copeland's fear of being found out that he had been talking to the police about the homicide of Donovan Thomas.
Well, it really doesn't go to that. You know, it's a response to a question. Right? And what the detectives are asking Mr. Copeland is whether or not anyone knew or asked him whether he was talking to law enforcement. Right?
Well, specifically Thug and Kente.
Right. Yes. If you look at line 8, I think the course was line 18.
Yes, sir. Yes, sir.
Have you ever been questioned by Thug or Kente or anyone else as far as you, have they ever asked you, are you talking to law enforcement? He says, not Kente, but Thug. And then we pick up from what I noted. So it certainly is hearsay, because Mr. Copeland is opining, he is giving his opinion about whether or not, or answering whether they had asked him about talking to the police, and this is why he thinks so. He talks about what Mr. Williams' father said, specifically, what he drew from that, what his opinion was of it. It's really not about the effect on Mr. Copeland, because he doesn't really talk about, well, because Mr. Williams' father said this, I did this. You know, he's really just talking about what Mr. Williams' father said and what he grasped from that, what his opinion was of it. That's not the same thing as the effect on the listener, right? That's simply his opinion. And there's nothing there to say, as a matter of fact, even if you look at the last line of the statement, That's line 23 on page 437. Actually, it's line 22. He starts saying, I don't know how he get his information, but when he said that, I thought he was just talking at the moment, trying to just scare me up and whatever. Right? It doesn't say that he scared me. It doesn't say that, I did this as a result of what that hearsay statement was. It just says what the person said and what he opines the person was thinking or trying to do. And so it is hearsay. And the truth is, it is being offered for, the state wants it in for the truth of the matter asserted. But it doesn't really go to anything. It's just his opinion.
Your Honor, but that's the key point right there. It is what Mr. Copeland thought as to why he is concerned about people finding out if he snitched or not. So whether or not, again, truth of the matter asserted is that we want the jury to believe that he's connected. I don't know or care if the jury believes if Mr. Williams is connected or not. What the state wants the jury to understand is that this conversation that he had, that Mr. Copeland had with Mr. Williams, informed what he thought about if people are going to know whether or not he told police about the crime, which is the murder of Donovan Thomas, and his concern about that. Truth of the matter asserted would mean that I want the jury to believe whether that Mr. Williams was connected, that I want the jury to believe that Mr. Williams told Mr. Copeland he could change his identity. I don't know if he can change his identity or not. That is not what the state is offering it for. That is offering it for the truth of the matter asserted, that Mr. Williams could actually go and change his identity. I don't think Mr. Williams works for FBI or any other agency that could do that. So that's not what we're offering it for, Your Honor. We're solely offering it about Mr. Copeland's, the effect that this conversation had on him and the fact that he was disclosing a murder to the police.
So, if what they wanted in for are the things they've just said, they want the jury to know that Mr. Copeland is concerned about his name being out there or him being labeled a snitch, or that he is talking to law enforcement. Then it's cumulative because they've already got that. There's already been testimony. I think the jury's already seen a portion of a statement where Mr. Copeland is talking about he doesn't want to be known as a snitch, that he didn't want any paperwork with his name on it. So there's been testimony about it. You've already let that in. Right? But what we're talking about here is hearsay, something that Mr. Williams' father purportedly said to Mr. Copeland. And, I'd understand, I would go with them, with their argument, if the transcript continued on and Mr. Copeland said, and, after he said that, I was, that made me really think about whether or not, I was being labeled as a snitch out here in these streets. Those are my words, obviously. I'm giving an example.
Yes, sir.
But it doesn't say that, right? So he's opining on whether or not anyone knows that he was talking to the police, and based on, and he thinks yes, based on what the hearsay statement is from Mr. Williams' father. But we've already got that. It's cumulative, and so we don't need this hearsay to add to the evidence that's already been admitted.
And Your Honor, I understand that Mr. Adams keeps saying it's hearsay. It is not. And the fact of the matter is, it's not cumulative, because the fact that, and especially in this part of the interview, he is telling a different set of detectives this information. He's actually talking to some IA detectives about information that's not going to come in at this point regarding Officer Beebe. And they're asking him, trying to understand, why are you coming forward now? What is your purpose? And he's beginning to tell them, again, what he's consistently said in this interview about his concern. And that is important, again, when Mr. Copeland is saying he made all this stuff up in court in 2024, everything I made up, I made it all up. They get to see that his biggest concern was being labeled a snitch. That was one of his biggest concerns in this interview.
I understand that, Ms. I do. I just don't think that this particular section drives home that point. I do agree with Mr. Adams. I think that it's cumulative, and it may be the relevance of it is because it really does not go to Mr. Copeland's fear in this particular circumstance. It doesn't. I think there are some other, or him talking about the police, speaking to the police and his concern being a snitch. I don't think it goes to that. I think he's just communicating third-party information from Mr. Williams' father, and it's not really kind of relevant for the purposes, at least in the court's opinion, as to this particular issue. Having said that, I'm going to exclude it. But again, if somebody opens the door up as to it and lays a foundation as to it, then I may revisit my decision on that. Okay. But right now, I don't think the conversation between Copeland relating about what Mr. Williams' father told him is relevant.
Well, Your Honor, while the state will just ask for continuing objection, we understand
you
the
can have
ruling. We don't believe.
DA Love didn't understand when she was talking about Woody saying that I met Thug through, procuring drugs and guns and all this stuff. You made that sound like an initiation. But at the same time, y'all don't have an initiation process, so that's out. Then turns around and it's like minimal amounts. If these cats are supposed to be big time drug dealers, where the pounds at? They about a zip, bro. Just a zip. I got homies right now. I'm not gonna say nobody's name because they just, that's how they do it. Smoke weed. I got homies right now. A zip wouldn't last them past 2 days. And these just regular smokers. Zips for some of these cats go by in a day. Now I know what y'all, bro, whole Ziploc bag, I promise you, they got nothing to do in life. All they do is invite homies over, play Madden or NBA, whatever the hell, 2K, and that's all they do. They smoke weed. These are the friendly weed smokers. I don't smoke weed. I don't drink, so it ain't me. But, bruh, where's the pounds at? Where's the droves of guns? See, the judge is finally starting to listen because he kind of snapped today like, yo, you just saying shit. You're really just saying shit. You're not even saying nothing. Adams made all of his points basically by exposing Judge. They're just saying anything, bro. They're really just saying anything and trying to see what they can get away with. You want to talk about coercion? The whole entire damn thing was coercion. Y'all got to look at it like this. The cop basically threatened Woody to say, we going to drop your paperwork and them cats that you over there with, they're going to knock your head off. Is that not coercion? Nope. All right. So how is it that you basically allowing the DA to tell them the consequences of their actions, not coercion? All right. Okay. All right. I see where y'all coming from with it now. I still disagree. But either way it go. The DA sucked today because I was thinking death by 1,000 cuts. No. I'm sorry. Let me apologize to you guys. I am sorry. Standing here, the channel of Sadie Nash is sorry. Because honestly, that's not the strategy that they're using. It's not death by 1,000 cuts. It's let's throw some shit and see if it stick. That's as best I can give you, bro. There was the whole entire video, in my honest opinion, if it ain't directly linking to crimes, why the hell are you bringing it up? You want to show the propensity of YSL from a dude who really ain't YSL. You try to say that it's basically a hybrid gang, right? Then you're bringing up unindicted co-conspirators. Bruh, you know what? Bring up a pizza man one day that happened to see Young Thug with some weed in his head, and Young Thug was rapping about shooting people, getting money, and having sex. And then you could say Young Thug is running a prostitution ring that also sells guns, and they're thinking about acquiring a pizza chain so that they can go ahead and go legal. Because the pizza guy sat there and was like, man, a good way to grow your money? We sell a lot of pizzas, bro. You might want to invest your money into that. So pizza is now YSL. This is what they damn near sounding like. And it's like, bro, I'm listening to this shit. I'm like, all right, where's Miss Love at? She obviously got something else to do. But, bruh, this looks goddamn dumb. It just does. She cited case law that was Brian Steele's shit yesterday. She turned around and basically talked about an initiation phase, and Keith Adams was right. Shawty, that would make sense if you put it in your closed argument. But right now, it doesn't make any goddamn sense. On top of that, Miss Hylton, baby, we gonna have to get you some money. We got to start a GoFundMe. That goddamn dress is horrible. I ain't even a fashion dude at all. I ain't brushed my beard or nothing. Listen. What the hell was that? Solid colors. You a chocolate lady, baby. You a chocolate lady. Solid colors. That shit right there looked like the Handmaid's Tale wives. I don't know, but that was just terrible. Like that was somebody's grandmama's handmade quilt off of her goddamn table. That was terrible. I don't even want to talk about. I don't know how to dress my goddamn, so I'm not a fashion nigga. But what I can tell you is, nah, baby. And it seemed like you trying to shake that ass for the camera a little bit. And if those are the type of dresses you rocking, I'm not throwing dollars. I'm throwing pennies, straight copper. Because, God, dog, what the hell was that? So bend that ass over. Get some solace, please. Just shake that ass for me. Just shake that. I'm joking. Nah. But nah, this is an embarrassing day, bro. Because, honestly, y'all revealed too much of y'all strategy that y'all just trying to put anything in there. And y'all don't give a damn about this case. This is basically trying to make shit stick. You want to put up basically 1,000 goddamn things and see if they going to mess around and catch it. I'm sorry, this shit looks stupid and embarrassing. And yesterday was pretty cool. Some of the stuff they had, I understood. But when Keith Adams is speaking, that nigga was on Super Saiyan fire today. I was like, because it's the sharp, concise stuff, not the verbose, over-talking stuff that other individuals in the case does. And it just is what it is. Do I have favoritism? Yep, I'll admit it. Adams is my favorite lawyer right now. Now, Sharp, I ain't gonna lie. He rising up in the ranks. He wasn't up there before. He like middle of the pack. I felt like my list was going Adams, Weinstein, Steele, Matthews, Sharp, and then Harvey, because Harvey ain't really said nothing. And it's like, he's supposed to be this big badass attorney, but bro, all I keep hearing you trying to do is sever, and everything you keep saying keep getting rejected. But Sharp about to get up there, bro. I don't know, man. We gonna find out. But court tomorrow, I'll catch y'all there. I believe court is tomorrow. And then they're gonna have Friday off, and then Monday, done. But I think Friday I'm gonna drop the video of Ms. Hylton. Nope. Not that video. I got a video about the lawyer that came in and represented Steele. And I know the play that they're running for the unredacted transcripts, because there could have been some. I seen this play before, studying one of these lawyers, and I'm going to bring it up Friday. Trust me, you do not want to miss that one. It sounded like 6% of y'all got your bells on. That's cool. Hey, but check it out. We are 20K away for that $1,000 giveaway. So, hey, we going up. We just hit over 8,000 subs in the last 28 days, so we could possibly make that by July, but I'm probably thinking it's probably going to be about the middle of August, maybe beginning of September. But if y'all subscribe today, shit, we could do it sooner than later. Somebody can get their summer popping. But I'll catch you on the next one.